Drage koleginice i kolege, poštovani članovi MČM-a. Ja sam Marko Jovanović i u ime Američke privredne komore u Srbiji želim vam dobrodošlicu na današnju panel diskusiju u organizaciji MČM-ovog odbora za privredno i poslovno pravo, koja za temu ima eksterno finansiranje pravnih sporova. Kako funkcioniše postupak eksternog finansiranja sporova? Koje su njegove prednosti i mane? Koji sporovi su podobni za finansiranje? Samo su neka od pitanja na koje ćemo pokušati da dobijemo odgovore na današnjem panelu. Kako je reč o aranžmanu koji se još uvijek nije u dovoljnoj meri odomaćio u našem pravnom sistemu, smatrali smo da su uporedne prakse veoma značajne kao jedna vrsta putokaza za buduću odluku vaših kompanija o opredeljivanju za ovaj mehanizam finansiranja. Zadovoljstvo nam je što danas imamo priliku da ugostimo naše cenjene paneliste, gospođu Christian Deniger, potpredsjednicu kompanije Barford, koja se uključuje iz Londona, i gospodina Jonathana Barneta iz kompanije Nivalion, rukovodioca za Austriju i centralnu i istočnu Evropu, koji se uključuje iz Beča. Thank you for joining in and welcome to the panel. Današnji panel će moderirati advokat Milan Lazić, potpredsjedavajući MČM-ovog odbora za privredno i poslovno pravo i stariji partner u kancelariji Karanović & Partners, i advokat Nataša Lalatović-Đorđević, partner u kancelariji Moravčević, Vojnović & Partners u saradnji sa Sean Herr. Pre nego što prepustim reč Nataši i Milanu, ohrabrujemo vas da uzmete aktivno učešće tako što ćete svoja pitanja postavljati putem četa. Imajući u vidu da panelisti ne govore srpski jezik, veoma bismo cenili ukoliko biste pitanja postavljali na engleskom jeziku. Kao što već znate, obezbedili smo simultani prevod današnjeg panela. Ukoliko želite da pratite tok diskusije na srpskom jeziku, molimo vas da kliknete na polje Interpretation u dnu ekrana i da odaberete opciju Serbian. Ukoliko pak želite da pratite razgovor na jeziku na kome govore panelisti, možete izabrati opcije Off ili English. Također, obaveštavamo vas da današnji događaj snimamo radi omogućavanja praćenja članovima komore koji nisu bili u mogućnosti da nam se pridruže. Link za snimak koji ćemo objaviti na YouTube kanalu MČM-a će biti postavljen na internet strani MČM-a uz vest o održanom događaju, pa vam skrećemo pažnju na ovu okolnost i molimo da nas obavestite ukoliko sa tim eventualno niste saglasni. Ukoliko nema primedbi, prepuštam vas našim moderatorima Nataši i Milanu da nas polako uvedu u temu današnjeg panela. Nataša, izvoli.
Hvala, Marko. Thank you very much. And I would also like to wish a warm welcome to all our participants today. Thank you for your time and for giving us an opportunity to present legal finance. As an introduction, maybe it is a good to sort of justify and explain why we selected this topic, because we know that disputes generally are not a hot topic, and except for probably lawyers, companies and our clients generally don't like to talk about them, don't like to think about them, and this really comes with a good reason. I mean, no one is eager to litigate, and it is always sort of a last resort. The reason for this is that disputes involve costs. These are costs of lawyers, of experts, of the courts and institutions administering the process, usually arbitral institutions. Also costs of in-house sources, resources which are dedicated to conducting the process. On the other hand, there is always a risk. Disputes inherently carry risk because the outcome is uncertain. And in between these costs and risks, there are companies with burden on their cash flow. And instead of investing the funds in expanding their businesses and in new investments, they would have to allocate these costs and the cash to dispute. There are, of course, other forms of financing, except self-financing, but also from loans. But this means that this only differs the risk and the cost that has to be paid, and with the loans, their interest incurred over time. It doesn't come as a surprise that as a result of this, a lot of claims is not pursued. Companies choose to forgo their claims, and based on some statistics from Burford, almost 2/3 of in-house counsel of legal departments of the companies choose to forgo certain claims because of the associated costs and the length of the process and the uncertainty that is involved. What we wanted to explain today and sort of introduce is that it does not really have to be this way, that there is another option, an option which is called legal finance, third-party funding, or legal litigation funding. There are different terms for this, different names for the same term and same thing. What we also wanted to emphasize is that it is an option that is practically a common practice in standard practice in common law jurisdictions. It is increasingly popular in Europe over the last decade, and it is not known and not sufficiently used in Serbia and the region. And this is what we wanted to talk about today, and then to show and present the way an option to conduct and pursue the claims, but with removing this cost and risk element. Maybe just a brief introduction into what a definition or legal finance actually is. What is characteristic when it comes to the legal finance is that the dispute you have or a claim became an investment. It means that the company would turn to a third-party funder, a litigation funder, for a capital to cover the costs associated with the process, litigation or arbitration. Of course, this capital comes with a price, and the price is a return on a success, an exchange of a portion of the award or the settlement. Now, what is probably the most distinguished feature of this option is that it is a non-recourse. And this is why it is attractive for the clients. Meaning, if you lose the dispute, unlike the loan and unlike self-finance, you don't have to repay for the funding. And the reason being that for third-party funders, this was their investment. There are different ways, and it's something which we will discuss in the course of today's webinar, but there is also an option to obtain an adverse cost insurance, meaning that it is an insurance basically against losing the risk, or losing the dispute, and obtaining capital to cover the associated risk of losing the dispute, court or arbitration fees, often cost of the representation of the other party, and so on. We will also discuss that it is possible to provide financing, to obtain legal finance for one single case, but also for a portfolio of cases. So there are many options available, and I would now turn to Milan to follow up on the introductory part, and then we will start interviewing our speakers and learning more about their experience and way their companies work. Thank you.
Thank you, Natasha, and good afternoon, everyone. It's a pleasure to be to hosting this panel. So, as Natasha explained, basically what third-party funding entails is that this is basically a tool where to which the companies resort to. And this is also in the cases where the company has no resources or funding to finance the case, to pay the costs of the proceedings, but also where there are sources, the company or a person has sources, but the company wants to use these funds for some other purpose. than to finance the costs of the proceedings and to transfer some of the risks to the third-party funding. This is an institute which is widely used in Europe and the US and worldwide, basically. However, this is not really common and known in Serbia and in the region. And I think it's very important for the members of AmCham, which are biggest companies in Serbia, to consider this approach and to transfer some of the risks of their disputes to third-party funders. So basically, this panel should give some basic explanations of how things work in relation to third-party funding. How do you approach a funder? What do you need to prepare? What kind of cases are funders likely to take upon? And most importantly, maybe the purpose of this panel is also to bust some myths about third-party funding, because people often associate third-party funding with something which is controversial, unethical, and sometimes even illegal, whereas it is not. There were countries where there were problems with admissibility of this institute. For example, Ireland was one example of this. However, most of the countries are funder-friendly, and things are running smoothly in that department. As for Serbia, and Natasha will correct me if I'm wrong, I found no reasons that this kind of funding would be either forbidden or unethical or even controversial in any way regarding Serbia. And although there are some issues to be discussed regarding third-party funding, such as conflicts of interests or confidentiality or disclosure of these arrangements to the judges or to the tribunal, liability for adverse costs, I think this institute should be seriously considered by local companies as well, as a way to improve their handling and managing of their disputes. So this is why we have Christiane and Jonathan to bust some myths here and to bring you with this concept, to bring you closer with this concept. Just as a brief introduction, Christiane Deniger is a vice president at Burford. I may say that Burford is maybe one of the most renowned litigation funding companies out there. They have performed, day by day, they are assessing their cases. I think the strength in Burford is that they have a really experienced teams of people who are, for years and years doing arbitration cases, and they're really experience in that area to assess the viability and merit of these cases. We also have Jonathan Barnett from Nivalian, which is a leading funder in continental Europe with 4 offices across Europe. And I also may say equipped with experienced team of lawyers who are there to assess the cases on a day-by-day basis. Jonathan is the head of Austria and CEE operation of Nivalian. So let's maybe move on to the questions that we have prepared for our guests, for our speakers, and Natasha will take it over from here. Thank you.
Thank you, Milan. Yes, well, as the products we are discussing today itself, so does the process of obtaining financing has its own particularities. It is not, it is standardized, but it is not a standard one. So it is probably best to start from the beginning. And I would ask Christiane and Jonathan to explain us, how does it work? Where do we start? If we need legal financing, what is the first step to do, and how does this process look like? Maybe Christiane can start.
Of course. And firstly, thank you for having me here today. It's a pleasure to be speaking on this panel. So in the normal course, we are approached by a company or a law firm with a memo setting out the general merits of the claim, as well as flagging any high-level issues, setting out the potential damages, as well as the legal budget for bringing that claim. Once we have that information, as Milan pointed out, we carry out the in-house analysis of the case ourselves, and we are capable of doing that quite quickly. Once we've satisfied ourselves that we think the claim is meritorious, we will suggest indicative terms to the claimant and its lawyers on what we expect we would like our return to be. And this is based on the budget and damages. Once those terms are agreed, we will present this case to our investment committee, And subject to their approval, we will seek to negotiate a suite of transactional documents. These tend to include, obviously, the funding agreement, a priorities agreement, and where necessary, a creditor standstill agreement or charge. This is broadly similar at most funders, though there are certain bits and pieces that can be carried out differently. And I'm sure Jonathan can tell you what that is.
Jonathan, is it any different in Valiant?
I mean, largely it's the same. And just before I get into that, I'd also like to say thank you very much to you, Natasha and Milan, and for all of you in the audience for joining us. It's a real honor to be speaking before you. I know it's now trite to say after all this time, but it would be lovely to be there with you in Belgrade. Hopefully in future, things will change and we can travel. But getting back here with funding, I mean, Christian has set out the main issues. Each funder, of course, has its own different procedures that slightly differ. But the main issues are that in terms of going from due diligence or receiving the information from the lawyers, undertaking due diligence, assessing the case, assessing the quantum, understanding what the commercial terms are, presenting those commercial terms to the client so that the client is able to consider whether or not it's willing to go forward on that basis, seeking approval from our investment committee, and then basically getting on board. One issue just to highlight is, yes, drawing up the commercial terms is based on quantum as well as the legal budget. There's a lot of back and forth discussions about what the budget needs to include. Is it just for the arbitration, for example, or is it for arbitration and enforcement set aside? What is the extent of that budget? What is the extent of the case itself? What does the client look for? What do we as the funder look for? And then quantum, in terms of the amount of the claim, it's always important to remember that when going into a dispute, especially as a claimant, a party more often than not, if always, will claim well in excess of what either the lawyers know it will likely end up with, or more often than not, what a court, a tribunal will order. For example, go in and claim $100 million and then get ordered or succeed and get ordered, $10 million, 1/10 of what is claimed. So these are the issues amongst many others that we, other funders, consider. And what we are trying to do is to create a balance and to gain an insight and from, say, a conservative to a best case scenario of what the budget, the quantum, how the numbers work. That as one aspect. The other aspect, of course, is looking at the case itself and seeing whether the case stands up to scrutiny. Thank you.
Thank you. And just a follow-up, is there any standard on how long the process lasts? Is it possible to give an estimate, or is it based on a case-by-case basis?
It's totally a case-by-case basis and really depends at what stage of the dispute the claimant is in. If it's later in the process, when you have all the pleadings, witness statements and whatnot, it's actually, to my mind, a lot quicker to go through that information than when you're at the beginning of a dispute's life cycle, because you don't know what the other side thinks yet. You don't know what their arguments are, though obviously we can anticipate what that is. But I would say it takes a minimum from start to signing documents of 4 weeks, because it is a lot of work and it does take a lot of analysis. And as Jonathan said, back and forth, not just on the terms, but on specific questions that occurred during the due diligence process.
Yeah, I'd add to that. I mean, the short answer to your question, Natasha, how long is a piece of string? Every case is different. One size does not fit all. Christian, you mentioned 4 weeks. I'd say that in our experience is, way too quick. A lot of what happens, we get the case in, and there are different phases of the process. The initial stage being that we obtaining information from the lawyers. So a lot of that information is either issues, whether it's legal, factual, or otherwise, that the lawyers either haven't considered, they have not discussed with their client, they have not obtained that information. So the ball goes back into the, say, client and the lawyer's side. Time keeps passing by, but that's not time that is say, on our shoulders. Then we receive the information, we process that. There may be additional issues that come out of that where we need more information. Then we go to external due diligence, and we're dealing now with a third party. Yes, lawyers, experts that we instruct, but they also have their own time frame. So there are many moving parts, many different issues. Our role is to balance all those issues to give the client, the lawyers, a clear, transparent, predictable framework within which they know when to expect things from us, what the open issues are, information that we require from the lawyers, from the client, and working together. So what I would say with all of this is that it's a relationship building exercise as much as it is a process of scrutinizing the case itself. And it requires a lot of work with the lawyers, with the client, to put all of this together.
And Jonathan, you're absolutely right that it can take substantially more than 4 weeks. But when you're at the end or close to the end of a life cycle or of a case, or you're seeking to monetize an award, you don't necessarily have the same, you don't necessarily need to have the same back and forth, which is why it can be much quicker.
Agreed, definitely. It depends where you are in the case.
I'm just one question from my side, which is related to this. There's a term of packaging the claim. So I understand that when a client has a claim, it needs to prepare it for the funder. My question is basically, how does the client has a claim? How does the client approach a third-party funder? Does the client needs to do some due diligence beforehand and prepare a case and give it to you for the assessment? Does he need to engage a lawyer for an attorney for this kind of an exercise? Or he can just plainly, approach you and then you do all the in-house work in terms of the assessment? That's maybe one question. Maybe we can start from there. Mm-hmm.
Christian.
For a client to come to us already with the lawyer. However, we are able to recommend lawyers that they can instruct. We generally prefer that some legal work has been carried out to at least set out at a high level what the claim is. So what happened, what went wrong, what went right, how much was spent, a bit of, and some information about the respondent, because otherwise we don't have much to go on to enable us to determine whether or not this is an actual meritorious claim.
Mm-hmm. Yeah, I second that, naturally. It's just, from our perspective, it's easier, more efficient, ultimately for the client, for us to work with the lawyers. The reason being, we look at the legal issues in the case, the facts, the law. And so by way of background, we are lawyers. We know what to look for. We know how a case is put together, what the strengths, the weaknesses are, what they could be, etc. So these are the issues we consider. Dealing with the client, this is outside the expertise or knowledge of a client. So it just makes communication easier, efficient. To answer your question, Milan, we do not go and do the work for the client. And to demonstrate by example, a worst case scenario would be, for example, the client says or contacts us and says, I have, for example, a complex dispute. I've got a room with hundreds, thousands of files in there. You're welcome to go and have a look and put the case together and see if you want to fund it. No, we don't do that. That's for the client to organize with a lawyer, with a law firm, for the lawyers to know what to look for, how to put the case together, and then to present that information to us so that we're able to assess the case from the ground up. Any further information that we need, we then work with the lawyers and ask those questions to obtain the information. But in terms of constructing the case, no. If a client needs guidance, of course, we can provide that in terms of you need to go to a lawyer. We, as a matter of policy, do not recommend lawyers. Of course, we're able to explain to the clients that there are lawyers available to give them information about legal guides and the like, which is to say the client is free to do what it needs to do to approach us when it's ready, and then we can start working with the lawyers to put the case together to see that our criteria, whether they can be satisfied or they can't be satisfied, whatever it might be. It's a work in progress, but much more efficient with the lawyers.
And one thing we should probably point out as well is obviously the client will be incurring costs from their lawyers at this point. At the time where Burford or Navalian chooses to fund that claim, we at Burford at least are happy to backfill the client and always will provide any backfill payment or costs that they have incurred in the course of developing their claim. And I know that is a concern of many claimants because they don't want to incur these costs unnecessarily.
Yep, it's the chicken and egg scenario. As the client, here I am spending money on lawyers to put the case together for the funder. We look at that matter on a case-by-case basis. It can be a case where if the case is funded as a result of what Christian is talking about, as a result of the client putting the case together specifically to apply for funding, because it gets funded, therefore the work that was done was relevant, it was necessary, not only for the case, but to get funding. Of course, we take that into consideration, and of course, we can and do include that in the funding budget.
Thank you. Also, very important questions for a client having a case, for a company or a person having a case is, what are the main factors that you weigh when you take a decision to take a case or not? What are the main elements? Is it is it whether the award will be enforceable? Is it the amount in dispute? Is it the legal team? What are the main reasons that you take a case?
Sure. Christian, shall we split this one?
Sure.
All right. Well, I'll kick off, if you don't mind. I like to often say that we start at the end when looking at a case. So it's, we work in a commercial world. So having moved from private practice in law, dealing with legal issues, now we deal with commercial issues, namely, does it make sense? Yes, no, what is the risk? Is the risk worth the reward? So with that in mind, the most important aspect of what we do is receiving the money, getting the money back. And what that means is the case is important, of course, but more important is to see that all things considered, if when successful with the case, what is the likelihood of getting paid? How is that likely to happen? So is it going to come, does this counterparty have a track record, for example, of paying or resisting payment, say dissipating its assets? What information is there that we can obtain and that the client can tell us, the lawyers can tell us? We might do our own due diligence with an asset tracer to understand how hard is it going to be to get the money if we can get it at all. So that's where we start at the end. Start with enforcement, start with recovery. What is the track record? What information, what transparency do we have about what we're likely to get ourselves into? How painful is it going to be? How do you turn an arbitral award, a court judgment, which at its bare basics, words written on paper. And if you can't turn that paper into money, into cash or assets, then it's really not worth the paper it's written on. I mean, it's as bare bones as that. So we look to ensure that the money's there, we can get it. And from there, we start looking at other issues. Those other issues are, Christian, I'll pass to you in a second, but let's start with, we've spoken already about the legal budget and the quantum, and what is the ratio between those two? If you have, using the same example, if you have a case of $100 million and the legal budget is going to be $10 million, you have a ratio there of 10 to 1. But let's say you have a dispute for $20 million, and just for the sake of argument, the legal budget is also $10 million. It makes no sense for us to consider the case further because the ratio is just too disproportionate. So they're two issues, recovery and the balance and the ratio. Christian, I'm happy to pass to you for you to continue, please.
Yeah, of course. So obviously, once we've considered the enforcement, and I agree, Jonathan, that is the place where we as funders have to start. We go and look at the merits. And just to point out, you can have the best case in the world, but we don't want a Pyrrhic victory. Whereas for lawyers, we're always happy to win or take on a complex or interesting case. When we as funders look at that case, we have to think what success means. So is success getting 1/10 of what we're claiming? Maybe that's good enough if the damages are high enough. But we need to consider what is actually going to be claimed and how that will play in with the merits. The merits are a fairly easy thing to distinguish. It's often quite easy to tell if something is a good or bad case on the face of it. But in addition to that, we consider the legal system. So which country is this litigation or arbitration being brought? What and how do the courts of that country tend to treat disputes of that kind? We also, and this is really important, look at the lawyers themselves. Does that law firm have a track record of success? Are they used to bringing these types of claims? And how have they done this before? And in a situation where those lawyers maybe aren't familiar with bringing, for example, an international treaty claim, we would never suggest to the client to change lawyers, but we may suggest that they consider having co-counsel join if the budget is capable of supporting that. And all of these things that we've talked about, enforcement, merits, the jurisdiction and the lawyers, all need to be considered equally, because you can't have a successfully funded case without meeting all of these criteria.
Thank you. Natasha?
Maybe just a follow-up and to pick up on the question that we also received in the chat box. So basically, when it comes to the case itself, extremely high value of the case or high expected damages are not a guarantee that the case will be funded or eligible for funding, because as you explained, it means that there are other factors which are considered. But at the same time, lower value of the claim also does not automatically disqualify it from the process and from consideration, because it is the ratio that is relevant for the funders, correct? So it is the ratio from the expected costs and the expected return in the process itself. So it's
yeah, that's it. It's for us, it's a commercial arrangement. Namely, what is the outcome or the likely outcome that we can see? So if we can work with the numbers and that the numbers are supported by a meritorious claim, namely all things considered, likely to succeed, likely to get the money back, then sure, here I am talking about claims for $100 million, really just for the sake of easy numbers, but it is striking that balance between what is the likely outcome together with what the budget is. And this is what, just going off on a tangent here, but what makes what we do, what Christian and I and other funders do, interesting, enjoyable, amongst other things. And that is that we get to understand each jurisdiction and how each jurisdiction works. So, you have certain jurisdictions which, in terms of value are fantastic. The lawyers' fees on the whole are reasonable. The work product is excellent. You have a sound, independent judiciary, which is able to enforce and render independent decisions. And that opens up a whole world of understanding, okay, we can take our model and fit it in this jurisdiction, and the metrics work even better here than they do, for example, somewhere else. So we take all of these issues into consideration. It's not, say, a cookie cutter approach. It's not just one size fits all and that's it. Yeah.
And what is standard in a dispute is to have two sides and lawyers, but now we have a third party which with a high stake in the process itself. Does it change the rules of the game? I mean, who runs the show? Is it the client still because it is their claim? Is it the lawyers? Is it the funder? How does it work when the funders are involved?
Well, as a matter of law in the UK and in most common law jurisdictions, the funders are not permitted to control the case. We are simply passive investors, and everything remains within the control of the client. At Burford, we run our offices globally in that way. We will never force a client to make a decision, whether that be settlement or otherwise. That being said, we are more than happy to provide strategic assistance and support throughout the life cycle of a claim. And given our vast experience and the fact that we've seen many, many hundreds of arbitrations and litigations in various jurisdictions, quite often we are capable of adding value, specifically in terms of how judges or arbitrators are likely to rule on things, because we've had access to those types of analytics and have set up our own database. But that being said, we do not require anyone to take our strategic advice.
Yeah, I echo everything Christian has just said. I think, you know, it's often referred to as third-party funding. The reason, amongst others, being that the traditional model, which of course still exists, lawyer-client, and then now there's a third party, the funder, providing the money. There's been, and there continues to be, a lot of debate, a lot of misperception, misinformation, and misunderstanding of a funder's role in the lawyer-client relationship. To state from the outset, a funder's incentive and motivation is to receive a return on its investment. As a result, the funder, everything we do to ensure and to protect our investment. So anything that goes contrary to our investment that could jeopardize the return, obviously we do not do, and we protect ourselves and the case against that. How that feeds into the relationship is that of utmost importance is that the lawyer-client relationship remains sacrosanct. We don't get involved whatsoever. The lawyer advises the client instructs the lawyer. Of course, the money is coming from the funder to pay the lawyer, but we do that pursuant to the terms of a funding agreement, which is transparent, it's clear, it's a simple mechanism. We receive the invoice, we pay it. We don't get involved in strategy decisions. We certainly don't get involved in telling the client what we're interested in and how the client's going to pursue the claim, regardless of what the lawyer advises the client. For us, we are a passive investor. We sit on the sidelines. By the time that we are funding a case, built into that decision for us to fund is that we have built a relationship or already have a relationship of trust with the lawyers. We know that the lawyers know what they're doing. We know that we have a good working relationship with the lawyers, and that by the time the case is underway and that we are funding it, we need to be, as part of our decision to fund, we need to be satisfied that we sit in the passenger seat and we let the lawyers drive. The client tells the lawyer where to go based on the lawyer's advice, and we pay. And that's how it works. And as Christian has pointed out, there are provisions. I mean, let's not get into legal doctrine and the like, champity and maintenance, etc. But there's centuries of case law and statutes in common law jurisdictions that have said specifically this cannot happen, only that can happen. So there's very clear guidance on the limits of a funder's role in the lawyer-client relationship.
Thank you, Jonathan and Christiane. Maybe the next question I'm interested in, and also local clients presumably, is what is the best time for a client to consider legal financing and to approach the funder? Is it before, during of an arbitration litigation? And maybe the second question, you can follow up on that, just to put it down to Serbian market. What kind of cases, what types of cases are best for funding? For example, is it damages claim? Is it what could be adapted to the Serbian market?
Well, to start with your first question, cases can be funded at any time in their life cycle. If it's at the beginning or before a claim has been filed, then the terms will reflect the longevity until an award or judgment is reached. So it may be slightly more expensive to reflect that you will be waiting longer until we see proceeds. If you come in towards the end of your claim, we have more information. We are more aware of the risks. So it might be less expensive. Or alternatively, we are capable of monetizing fully or partially an award or judgment, which is often somewhat the best outcome for certain clients who have litigation fatigue or just want to have an immediate injection of cash. And before I hand over to Jonathan, to my mind, there are no cases that aren't capable of being funded. It all depends on what your own internal investment criteria is. For example, we do not get involved at Burford in family disputes. And by family disputes, I mean divorces or anything to do with family law, realistically. But relating specifically to the Serbian market, I mean, mining cases tend to be extremely good, or pharmaceutical cases. Outside of that, general breach of contract cases tend to be the bread and butter of funding because those relate to every industry. And I don't want to oversimplify this, but we can fund and do fund almost everything. And Jonathan, I'm sure you'll agree with that.
Yep. Stay away from the divorce and the like. You know, a reason being, of course, you know, divorce proceedings, there are so many other issues going on, potentially agendas, hidden agendas and the like. How that translates to us is that the risk is either not manageable, quantifiable, predictable. What I would add to what Christian has said and to the question is, you know, to invert the question, not when is a good time to ask for funding. Christian has answered, I mean, exactly the way we approach it. Come to us, we're happy to consider it. When is a bad time to ask for funding? So to demonstrate by example, also by experience, a lawyer's calling up and saying, we have a great case. We're going to file in 2 weeks' time. We need funding. We think we need funding. We have come to you, Ivalion. Let's do this. And why that doesn't work, there are just no reasons why it does work. I mean, timing is terrible. We also have our own pipeline of cases that we're dealing with. We accommodate many things, but if we're put in a position where it's rush, and either we have to shortcut our procedures, we can't address certain things. 2 weeks, of course, is an extreme example, but I've had that. Then it's simply from us, look, we can't do this. We're not interested. Thanks very much, but goodbye. So a good time to approach funding is to give the funder and the client as much time as possible to allow for these procedures to go through. Certain risks are where there are statute of limitations issues. And so the client approaches or the lawyers approach the funder, and there's already this pending dramatic issue that's just waiting there day by day. Yes, we can meet those expectations, but the question is for us whether it's worth committing the time and the resources, especially when the case is being prepared for, say, a substantial period of time. Why has the client not already approached us or other funders? So in short, it's just common sense. The more time that you have to prepare, the better off everyone is. The lawyers, the funder, the client, the more consideration can be given to certain issues. And without question, approaching us, approaching a funder does add value, whether or not the case is funded, but just going through the process of having the case stress tested, the lawyers turning their attention to issues that they usually have not considered, adds value. It broadens the scope of the dispute. It allows for there to be further consideration for example, of the strategy, enforcement, recovery. So all of these things do take time, they add value, but if there is this quick time frame, it's not going to work. I think that's the best way I can put it.
Thank you. Natasha?
Thank you. And just following up on the types of cases, and again, referring to the question, thank you for the follow-up. Funding can go towards claimants, but also towards defendants. Can you maybe explain a bit how it works when the defendant is funded? And the particular question we got is, what is the probability of the loss threshold for you to accept to finance the case? So now looking at the other opposing side, so to say, from defendant's perspective.
So funding a defendant is certainly possible. It is more difficult because what you have to do is be able to agree with the client what success means. And that can be a difficult definition to achieve in these circumstances. So where a respondent corporate has, we'll say, a claim of $10 million against them, and we fund the case, and they wind up having to pay half of that amount. That is better than the original outcome, but is that a success? And do they have to pay us back? It's doable, we've done it before, but it is a very difficult thing to do. Unless you are funding a portfolio of claims for one company where the damages are cross-collateralized across all the claims, then you can have one or two respondent-funded cases within that portfolio because you're protected by the damages of the other claims.
Yeah, that's about it. I mean, defense funding depends on how you define success, and that can be in many ways. On a one-to-one basis, it's more challenging. In a portfolio, it is easier. You can have an anchor asset. Let's say you have 10 cases in a basket, then you're able to cover your risk with, say, all you need of the 10 cases, for example, is that 2 cases succeed or 3. So then you have a lower threshold for the remaining 7. And of the remaining 7, you can have an even lower threshold for, say, 2 of those 7. So there's a much broader scope to fund more cases. And included in that, you can then take on a defense case, which allows you to know that you're going to be, the risk is already covered by other cases, and that there is a potential real upside to benefit from the other cases once the defense is successful, depending again on how success is defined. But Natasha, sorry, you asked another question, which has just jumped my mind.
Yes, so the question is, what is the probability of loss threshold for you to accept to finance the case?
So the loss threshold in terms of defense funding or in general?
Defense funding.
Well, is a loss nonetheless a success, given Christian's example? You know, you go into a claim, again, for simple numbers. The claim against the defendant, who is the funded party, is for $100 million. The tribunal, the court, makes an order for the defendant to pay, let's say, $20 million. So instead of paying $100 million, they only have to pay 20. So by being funded and being able to fund a successful defense, as the funder, we have benefited the client $80 million. So there's no actual threshold. I can't give you a number. Every case is different. It just depends whether, considering all these issues, we're able to make the numbers work, whether it makes sense for us to get involved, as well as for the client to consider funding with us. And that's a real concern. Well, not a concern, it's a real consideration we have. Namely, is the contractual arrangement fair? Does it make sense for the client? We're not interested in taking the lion's share, you know, that however much is awarded, and we take a significant percentage of that. In many jurisdictions, in any way, in either way, that's unenforceable, against public policy, whatever it may be. So these are issues we consider. In a basic sense, It's just easier for everyone. The contractual relationship works, that it is a success when there is a success, that we receive what we said we would take, and that the client walks away satisfied with the arrangement. So these are also things that we consider. How can we make this work? And that at times is a necessary part of the relationship we construct with the lawyer, with the client.
Thank you. And just coming to the main point, probably, or the point that is of most concern, is how much does it actually cost? I mean, I understand it depends from case by case basis, but in average or just in impression, how is the price determined for legal financing?
Well, this is largely determined on where the claimant's claim is going to be. If it's a jurisdiction that is friendly, how long the case is going to take. So it's really hard to tell you how much it costs. That, though, you can expect that we would want our investment back, so what we actually spent, plus the greater of a multiple that would increase over time of that spend, or a percentage. And the percentage is determined by how risky the case is ultimately. And that's why it's very difficult for us to say this right now, or for me to say it. I suspect Jonathan will feel the same. I would never want to pigeonhole myself to being restricted to certain terms.
Sure, but for the sake of giving a range, I would say that firstly, most, if not all, commercial terms are time dependent. That being, if the case finishes, whatever that means, but let's say it finishes within 12 months, then either a certain percentage of the amount that's recovered or a multiple of what we spend, a greater of the two, will be at a certain level. Then if the case goes for, say, from 1 year to 2 years, that amount will increase, not significantly, but incrementally from, say, 2 to 3 years, and then it might cap out at, say, 5 years and beyond. The idea, the reason behind that being that the longer the case goes, the more we spend, the greater the risk we take, and therefore there is an incremental increase in those numbers. To give a range, I mean, funding in terms of percentage can range from, say, anywhere from we take 10% of the proceeds up to, say, 30, 35%. But those numbers really depend completely upon what numbers we're dealing with. I've been involved in disputes for, in excess for many billions of dollars, huge amounts of money. But when we're talking about that, we talk about taking a percentage, which when you're talking of, say, 1 or 2% of the amount that you recovered, 1 or 2% doesn't sound like much. You convert it to the amount that you're dealing with, it's a very significant sum. Reverse that and say you're dealing with a dispute for $30 million, for example. Well, 1% of $30 million doesn't make sense for us commercially. So then the amounts increase. You can also have the budget, say, for a dispute for, say, $30 million, usually is not going to be that much different for a dispute for about $100 million. The lawyers are going to have to do more or less the same type of work, the same amount of work, with the same amount of time, or whatever basis it is that they construct the budget. So all of these issues go into consideration, and we run the calculations. We provide the client with certain scenarios, examples, so the client and the lawyers are able to understand how this could work out over different time periods. And all things considered, it is a transparent process. The client, by the time the client looks to enter into a funding agreement, we need to be assured that the client is aware of all of these issues, is satisfied with them, and willing and able to enter into the agreement. Again, because you're getting into a relationship for 2, 3, 5 years. A dispute by its very nature is a challenging process. It can be also traumatic for clients. We're aware of all of this. We need to start out on a strong foot, have a strong relationship, and then that sees us through for the rest of the dispute.
A quick one. What happens if the client wants to settle? Are you involved in that process, or can you prevent the client from settling? Christian
does not prevent clients from settling. Some funders take a different approach, but we are completely passive in that respect. And if a client wants to settle, brilliant. Hopefully it's quickly and we can get to proceeds quite quickly. That being said, we like to be kept informed of any settlement offers or rejections. And that is the most we would request in settlement discussions. We don't seek to be involved in discussions. We don't seek to control the lawyers or how they go about taking those discussions forward. And I think that's really important for clients to know. We do not control them at all.
Yeah, I add to that as well. And I hope the interpreters, I'm not sure the saying in Serbian with this one, but for us, a bird in the hand is worth two in the bush. So the quicker a case finishes, whether it's by settlement or by a court order or otherwise, the better it is for us. We get our money back. We may not receive as much as if the case had gone on for years and years and years, but because our entire process is based on risk, there is no more risk. So we're happy for the case to settle. We do not get involved in the settlement. We ask for, just as Christian was saying, to be informed of this. What we also ask and require is that the client agrees that it can only make or reject or consider an offer to settle on the advice of the clients, on the advice of the lawyers. So the lawyers act as gatekeeper. So we need the assurance that the client is acting on sound advice, independent advice, and is not entering into settlement discussions for some other purpose. It may have a hidden agenda. There might be something going on. The client excludes the lawyers from that process, and before we know it, settlement is reached on terms that are, whatever it might be, but make no sense. Let's put it as a worst case scenario. So what we require is for the lawyers to be involved in that process at each step of the way. That gives us the assurance that, yes, matters are proceeding in a diligent manner.
We have one question from the audience. Marco, is it okay that we prolong for 5 minutes just to wrap up?
Yes, please continue.
So we had a question from the audience. There was a mention of loss insurance. Who usually procures such insurance, a litigation party or the financing company? Could you just touch upon briefly about, what are the products there in terms of the insurance and who procures that? Do you help also the client in that respect?
So after the event insurance is something that's quite common in cost shifting jurisdictions. So when you have the losing party having to pay the legal fees of the other party, there are brokers in Europe and in the UK who can assist with obtaining ATE. The funders themselves, we ourselves can assist with that. And unlike most other funders, we have a captive ATE insurance product within the Burford products that we offer. And generally speaking, ATE providers need to see the same types of documents that third-party funders need to see. So we are happy to assist with lining up the information or telling you what information you would need to provide to any potential ATE provider. And getting funding does not necessarily guarantee being able to get ATE. Each insurance company obviously has their own risk criteria, but it is something that we're seeing more and more often.
Thanks. Natasha, I presume you will ask the last one.
If Marco allows. Yes. Well, we, already from Christian's and Jonathan's responses so far, we saw that there are things that funders have in common, but that there are also differences. And in your opinion and from your experience, what distinguishes one funder from another? maybe Jonathan, you can say.
Yeah, sure. Well, we offer a commercial product, so the commercial terms is the most obvious. Same case, we will offer certain terms. Burford will offer, no doubt, different terms. So that's to say that it's an open market. Clients are encouraged. I mean, we do encourage clients to go and look around and to find what's best for them. Ultimately, if the client is happy, that makes for a better relationship going forward. Other things to consider, let's say there are credible established funders out there, like Burford, like Nivalion, and others that have a history, a very strong track record, have been in the market, have created the market. So that's one very important thing for clients to consider. Who is the funder? The client needs to, we recommend very much, the client should do their own due diligence on the funder or the funders that they're approaching to ensure that the funder has the capital adequacy, that they know what they're doing. There are others out there that say that they're third-party funders, but they can either be masquerading as brokers, so dealing with other funders behind the scenes, that they themselves don't have the capital adequacy, they don't have experience in funding. So it's important to understand who the client is dealing with. And different funders distinguish themselves in different ways, but it's, there are certain leading funders. It's easy to see, they know what they're doing. Christiane?
I agree with you entirely, Jonathan. And I would suggest that anyone looking to get funding, if for whatever reason they're not calling me or Jonathan directly, they should check out the Association of Litigation Funders website. That is our self-regulating body of funders. And you have obviously Nivalion and Burford both leading within that. Or secondly, ILFA, which is the International Legal Finance Association based in the US. And as a result of being members of either of these two associations, there's certain requirements that are really quite important. And Jonathan touched on the liquidity or capital requirements that a funder should have. The worst case scenario would be to have a funder provide funding for you to simply go bust within a year and not be able to afford to continue. And that is something that unfortunately we do see and we'd like to remove entirely from the market. So please do your due diligence before going with any specific funder.
Thank you very much. Well, I see that we are not running out of time. We are out of time already, but I think we managed to cover all points that we thought were relevant for this introduction. And it really is an introduction into this topic. There are many more things to be said, but the general idea today really was to show that there is an opportunity and an option to be further looked into. So there is an opportunity to pursue the claims while sharing the risk or limiting the risk entirely, and really allocating the sources that companies already have to a different project, a project that will enable them to invest and further develop while the cost for dispute is parked with a third-party funder. From my side, that will be the wrap-up. Milan, I turn to you.
Nothing left for me but to thank everyone for this interesting discussion. I hope that we will continue discussing this, and we can maybe go into more detail in the next round of this discussion. And I think this is a good basis for companies and also individuals in Serbia to start using this very, very useful tool. So I would like to thank everyone, thank the attendees, thanks MCHAM, in particular Natasha, Jonathan, and Christiane, and to say goodbye to everyone. Marko, do you want a couple of closing words, or that's it?
Yes, thank you. I'll switch to Serbian right now. Meni je preostalo da ispred MCHAM-a kao organizatora današnjeg događaja zahvalim i našim panelistima i moderatorima na učešću, kao i vama u publici na vremenu i interesovanju. Prijatan dan i pratite najave naših narednih događaja.